Supreme Court or AT, whatever the department. And after that, we will take the query that has been either that has been submitted through Google form, or if any participant want to ask question directly, so they may also ask the same. So we are moving toward our first part, the important case law that has been issued in the first part. So first case law that I have taken for the session is related to the refund. In the case the taxpayer has applied for the refund in case of export of services, and the department has rejected the refund claim. Yani it means educating authority has rejected the refund. Then the taxpayer has approached to the appellate authority and filed the appeal before the appellate authority. And the appellate authority has taken a decision in a way that has raised the concern towards the taxpayer, and they have approached to the High Court. So the basic law under GST is that if you are filing an appeal and appellate authority is, after considering your point, appellate authority must have to decide an opinion whether they will accept the point that has been raised by the officer, or that point has raised by in the order, so whether the department appellate authority will accept the same, that no, the authority is true, authority is correct. Otherwise, appellate authority have another option that they may reject the same. That the adjudicating authority has passed the wrong order and it will be in the favor of the taxpayer. And the third will be the either the department will decide the case according to the case, that yes, this will be the particular thing that I will take care in the favor of the taxpayer, and another point will be rejected. So there is one important point is there, that under the GST law there is no concept of refer back. Appellate authority can't refer back the case to the adjudicating authority. In the particular case, appellate authority had refer back the case to the adjudicating authority to listen the case again. So the taxpayer has filed the case before the Allahabad High Court and raised the concern regarding whether the appellate authority can refer back the case to the adjudicating authority. And Allahabad High Court has passed the order that appellate authority has only three options: either confirm or modify or annul the order that has been passed by the adjudicating authority. So the case has been referred back to the appellate authority to pass the order, not you have to pass the order, you can't refer back the case to the adjudicating authority. So it was the first case that we have taken. If in any case, if you find that the appellate authority is not making a decision referring back, then you can take the benefit of this case laws that have been issued by the Allahabad High Court.
Right, Gaurav. I think this is one of a kind judgment here, because
Yes.
the similar provisions I think already existed in the Income Tax Act, where the appellate authority cannot, remand back the case to the original adjudicating authority, or I think we call the assessing officer in the Income Tax Act. But these provisions were not there in the service tax or the central excise in the old regime, I must say. So 75 section 75 specifically includes that the appellate authority cannot remand back any case. They can either pass the order, reject the order, modify or annul, but they
Yes.
can remand back the case back to the original adjudicating authority. I think I also dealt with a similar case with the appellate authority, where they were very much inclined to remand back the case. But when I specifically showed them this provision, they were also not aware that yes, do not have that power now to remand
Yes.
back the case to the. So most of the authorities, especially in the State Department and even the Central Department, because in the service tax time it was allowed. So most of the appellate authorities are not aware of this provision under Section 75, and I think most of the fraternity is also not aware. So we should be very careful, and we should be very, see that the cases are just getting decided at that level only, whether in our favor or against our favor, but it is not getting, remanded back to the original adjudicating authority.
So our next case, moving to the next case, it is related to Gujarat High Court. Okay. So the case is related to EV bill and the penalty. In this case, the taxpayer is a person who may export of goods, who supply the goods outside India, and involved in the business of the export of goods. So in a case, the taxpayer has issued the goods for export and the EVA bill got expired. Unfortunately, the vehicle has been detained by the department and the department has charged the penalty, 200% penalty as per 129. Now the taxpayer has filed the appeal against that order. Since we are involved in the export of goods, and in the case of exports of goods, there is no tax part. So tax is not involved in there. The tax is not required to pay. It will fall under the zero rate supply. So the taxpayer has filed the appeal before the appellate authority that in our case, as per section 129, the penalty will be 200% of the tax. In our case, tax will not be applicable as we are exporting the goods. So tax will not be there. Since the tax will not be there, then 200 penalty will also not be applicable in our case. So appeal has been rejected. Then they file appeal. They file case again in the Gujarat High Court, and Gujarat High Court has listened the case and discussed the case very carefully. And they have also referred the case to Micro Wagon Retail Private Limited versus Union of India, where same kind of matter has been taken by the Union of India. So the Gujarat High Court has passed the decision in the favor of the taxpayer that since the tax is not involved, it is zero rate supply and export related to export of goods. In such a case, the penalty will also be not be leviable. So now here the important point is important point is if you are supplying any goods for export of goods and even unfortunately or by clerical mistake any documentation issue is there and the department has detained the vehicle, department has issued the penalty order against you, then you may fight before the appeal with the case of this case with the help of this case law. The since tax is not applicable, hence the 200 penalty will not be applicable, and the Gujarat High Court has issued in the favor of the taxpayer.
Right. So this is of Gujarat High Court, right?
Yes.
I mean, there are a lot of jurisprudence under e-way bill now that when and where should the penalty be levied. There was a
Yes.
circular also, but as far as I have seen, department does not follow that circular.
Yes.
Especially in this period where there is a high recovery pressure on them, they try to levy penalty every now and then on every small or procedural lapses. So it's good that we are getting good judgment, but I think it is a need of an hour that the department also understands at the lower level that detaining the vehicle and levying 200% penalty, entails a lot of cost on the taxpayer. As the vehicle is detained, first of all, for the 2-3 days, it is released sometimes after a week or a 10 days, and then 200% penalty they pay,
Yes.
and then they go for appeal and then refund. And that is also a long process. So, according to me, something should be done at the lower level so that these vehicles are not detained unnecessarily.
Yes. Moving toward the next
So,
case.
there is, sorry to interrupt,
Yes, it's okay. Yes.
the Govind Otwani ji has said that if you can mention the case law's name also by speaking.
So it's Messrs. Asirvad Food Industries versus Union of India, dated 4th March 2026. Sorry, I have taken the next case law. So it was case Balakrishna Industries Limited versus Union of India, dated 10th March 2026, Gujarat High Court.
Yes.
Yes. Now moving toward our third case, it is case law is Mrs. Asirvad Food Industries versus Union of India, and the case is related to Jharkhand High Court. Okay. In this case, it is also a very practical case where the taxpayer has a huge amount of demand order and they move to appellate authority for filing appeal. In such a case, they have to deposit 10% as per the law. You have to deposit 10% before to 10% of the disputed tax to file an appeal. So taxpayer has filed appeal with depositing 10%. Now appeal has passed the order partially in the favor of the taxpayer. So the amount of deposit that has been made now is take an example that the case was for 1 crore, 1 CR, and the deposits had been made 10 lakhs. Now the department has passed the order and they confirm only 10 lakh demand. But the taxpayer is not satisfied with 10 lakh demand also. They file an appeal before GST 80. They will move toward the GST 80 for filing the appeal against that 10 lakh also. So now in our case, the deposit had already made 10 lakh while this because the original demand was of rupees 1 crore. Now the case has come to only 10 lakhs. So for filing appeal before the appellate tribunal, you have to pay additional 10%. So now the question that has arrived here, the whether we have to deposit another 10% of the 10 lakh demand, or if the amount that we have already deposited at the appellate level is so much exceeds the actual demand amount that is confirmed by the appellate authority is only 10 lakhs. So whether we have to deposit remaining 10% of the 10 lakh or the already deposit amount is sufficient. So they move to the High Court on this basis. The High Court has listened the case, and High Court had decided in the favor of the taxpayer since the earlier deposit, because the earlier demand was not genuine and the appellate authority has lowered the demand amount, hence the deposit amount is already excess to the statutory 10% deposit that is required before the filing of GST it is, and the taxpayer is not required to deposit additional 10%. So there are certain cases where we have also filed the appeal before the appellate authority and appellate authority has reduced the amount. In general, we are depositing additional 10% of the remaining disputed amount and file appeal before the appellate tribunal. But in this case, Jharkhand High Court has taken the case and passed the order that if your early deposit amount is covered, the final demand amounts 10%, like the final demand amount in our example is 10 lakh. 10 lakh, 10% will be only 1 lakh. We have deposited 10 lakh. So in our case, we don't have to deposit further 10%. So this is also a good judgment that has been passed by the Jharkhand High Court. The case name, again, I am repeating, Mrs. Ashirwad Food Industries versus Union of India.
Right. I think you can move forward.
Yes. Now the next case law is relating to the Himachal Pradesh High Court, and the case name is Deepak Agro Industries versus State of Himachal Pradesh. Here, this case is related to the adjudication where the submission made by the taxpayer has not been considered in proper way. So in this case, the taxpayer has received a notice. Against the notice, the taxpayer has submitted the detailed reply and they have also mentioned that we are depositing. In the detailed reply, they have mentioned that we are depositing the disputed amount along with interest, but it is disputed. We are not accepting the demand. It has mentioned in the reply, because once we pay the tax through DRC 03 or payment to our demand option, there is no any payment option where you could select that we are depositing on dispute mode. So you just have to pay either selecting the liability ledger or through form DRC 03, where you can mention in the remarks, but there is no specific form for the payment toward demand. The taxpayer has submitted a detailed reply along with the DRC copy that we are depositing this amount of tax and interest under dispute, and then file the reply. The adjudicating authority has taken that deposit as acceptance of the liability and passed the order that the amount has already been paid by the taxpayer and the case is dropped. And they have not even went through the submission that had been made by the assessee. Now the case moved to the appellate authority. After that, appellate authority has also not passed in the favor of the taxpayer. Then they moved to the Himachal Pradesh High Court and submitted the same, that we have submitted the payment of tax under dispute and we have made the submission. Department has not considered the submission and taken that disputed submission as a confirmation of the demand. The Himachal Pradesh High Court has listened the case, and then they had passed the order that the adjudicating authority must consider the detailed reply that has been submitted by the taxpayer. After that, they could only draw the decision that whether they have accepted or not, and the case has been concluded in the favor of the taxpayer.
Again, one more judgment on principles of natural justice.
Yes.
I think every now and then, I think everywhere I see all the cases like this of all the majorly of all the high courts where either the personal hearing was not given or the
Yes.
submissions were not considered or the show cause notice or ASMP 10 was not issued properly or the detailed order was not passed. There are a lot of issues in GST. Under the old regime, I believe in the service tax and the central excise regime, these issues were there, but they were not at this level that all the the taxpayer has to fight only for the natural principle, only on the principles of natural justice, just to hear them out, to consider their reply or to consider their appeal. So again, one more case, but again, this has been remanded back, right, Gaurav?
Sorry. Yes.
This case,
This.
this is
Yeah.
remanded back to the original adjudicating authority to hear the case
Yes.
again.
Yes. Original adjudicating authority
So
to listen the
whether
case.
you consider this as a relief or not a relief, once again, but again, this has been remanded back. The order is not caused, so we are back to square one. Okay, Rakesh
And the same kind of
Gulati.
yes, same kind of situation happened in the where the for the financial year 17, 18, 18, 19, and 19, 20 financial year time barring was so close to each other. And for example, the GST, Delhi government has also issued a circular because the sometimes the government the department has passed the order without mentioning the actual without passing the speaking order. They just mention that the reply is not satisfactory
Correct.
and
Reply is not
the order.
satisfactory.
And the government has issued the circular that every case that has been passed against the taxpayer mentioning that reply is not satisfactory, you have to re-listen that case and allow the rectification for all the taxpayer. So,
So, yes, yes, yes. Secondly, is even what I have seen is in many of the cases, what the department
yes,
do, they ask for the word file of our reply, and they
yes,
copy paste that word file in our reply in their order, and then at the end of it, or after every ground, or after end of the reply, they write that the reply submitted by the taxpayer is not satisfactory. So even reproducing the reply of the taxpayer and not making any discussions on the same that why it is not as satisfactory is again constitutes a non-speaking order. It does not
yes,
mean that if you have mentioned or you have copy pasted the reply of the taxpayer in your order that you have considered the taxpayer submissions and it is a speaking order. No, it is again a non-speaking order against which again which this is a violation of principles of natural justice and the writ again in the high court can be easily filed.
yes. Now moving toward the next case, it's related to Calcutta High Court and Justin Bhutia versus State of West Bengal. This case is also related to interpretation points of view, and we know, where we file any reply or any submission against either notice issued in 73 or 74 or other 74A. Now we have to properly see that what are the provision they are mentioned in section 75 because section 75 is very important for the 73 and 74 proceedings. So again, one case is related to section 75(4). Section 74, 75(4) talks about the issuing a personal hearing but for the personal hearing. So whether the personal hearing is compulsory or not. So under section 17(5)(4), it is mentioned clearly mentioned that if the taxpayer asks for the personal hearing, then only personal hearing is compulsory. If you have not asked for, then it is not compulsory for the mandatory for the department to issue personal hearing. They have to issue reminder to you. They issue the reminder, but personal hearing is not compulsory. Now, in a case, the taxpayer has not replied the so-called notice, supposing that the personal hearing will be allowed to us. But no personal hearing has been granted to the taxpayer. Taxpayer filed the case before the Calcutta High Court. Calcutta High Court specifically mentioned that Section 17(5)(4) doesn't mandate the authority to provide personal hearing unless you ask for the personal hearing. So for us, it is very needful. It is very needful to understand that. when you want personal hearing, you must submit before the department. You may raise the department while you submitting the reply. On the reply portal, there is a point tab where you have to select whether you want personal hearing, yes or no. If you will select yes, then the department is mandatorily have to provide you the personal hearing. But if you don't submit, or if you can't if you are not able to submit request for personal hearing online, you may submit the letter to the department offline also. But if you don't ask from the department, then it is not mandatory for them to provide you the personal hearing. So that is the case in Justin Bhutia versus the state of West Bengal.
I think Gaurav, as far as I remember, there was
Yes.
one case again of some high court. I don't remember the high court name or the case name, but the similar issue arose. There, similar facts were there that by mistake, or the consultant whosoever filed the appeal did not
Yes.
click yes on the, because there is a tab where you have to slide that
Yes. Yes. Yes.
while
You have to
filing
select.
the appeal to that personal hearing wanted or not. So, and by default it is on no. You have to select yes. So
Yes.
when you are going to file, when you are filing the reply on the portal or the appeal on the portal, by default that personal hearing option is set at no. And
Yes.
so what was the contention that they forget to, click yes on that, and by default it was no, so it was considered. So personal hearing was not given by the department. What High Court
Yes.
in that case specifically said or ruled that the personal hearing or is the right of the taxpayer, even if even if it is selected on the portal that no is selected on the portal, then by the law it is mandatory for them to give them the personal hearing. Otherwise it will be a gross violation of again principles of natural justice that we are talking about, by not hearing out the case, because it may, because there may be many cases where where the person who does not have much knowledge about the portal is filing the appeal on the
Yes.
portal or the reply on the portal, whatever it may be. The said person may not click yes on that, or okay, may not slide that button to yes. So again, this will be very prejudice to the taxpayer, as the default
Yes.
setting is no, or the default setting of that button should be we should keep the department should keep that to yes only.
Yes. No, so there are two things. The case law you discuss that there where the department has passed the it's a principle of natural justice to provide them the personal hearing. Okay, here the case was filed on the ground that whether it is mandatory for the department, the taxpayer has raised the concern whether it is mandatory. So as per law, it is not mandatory.
Hmm.
Now the next point comes, if we don't get this kind of benefit and the order gets against us, then we can take the benefit of the natural justice, but we can't take it so lightly. So our point is that whenever you file the submission, you must, because some high court taking the different view, so why we would take the chance in our case, we
Right.
must consider that if you are filing any submission, so you just select that you need personal hearing. Sometime department, if sometime when you submit the reply, it is auto selected no, and you can't even change.
Right.
In
Right.
that, yes, in that case, you submit an application in hard copy so that it will be in support of you that you have requested for the personal hearing. Yes, in certain case, if the department is not allowed, we can fight with. There are certain case law which are in favor of us. We can fight with the department, but in a general scenario,
Obviously, we
you
should
must
keep,
take.
we should be vigilant. We should be careful while filing the appeal or the reply.
Yes, yes,
Yes, there. I think nobody wants to get into unnecessary litigation,
yes, yes.
but
That's the
there
point.
are
That's
divergent views of different high courts. So obviously, we should be very careful while filing the appeal.
yes.
That's always.
So it was the first five case law. Now the remaining case law will be taken by Ms. C. Ayush. Yes.
Thank you so much, Gaurav. Good afternoon,
Thank
everyone. Once again, welcome to the fifth session of Weekly Knowledge series, organized
you.
by Animesh Legal Consultants. Without wasting much time, the first case that I would like to discuss with you all is of the Emergent Process Management India Private Limited, Gujarat High Court. Very interesting case law related to amalgamation and the transfer of ITC by ITC 02. The question, the facts in this case was that the company A merged into company B. So the company A is a transferor company and the company B is a transferee company. And company B is the petitioner or the litigator in this case. So when company A tried to avoid the NCLT, other day got merged. When company A tried to transfer its ITC balance lying in the E credit ledger to company B by filing ITC 02, it could not file due to some error. And after repeated reminders to the department and the oral follow-ups, finally the department rejected the ITC 02 of company A, saying that the ITC can be transferred only in the same state. So the peculiar fact in this case is that the ITC was company A and company B are registered under different states, and company A was transferring its ITC to company B, which is registered in a different state. So the department clearly said that, or the officer clearly wrote in while rejecting the ITC 02 form, that it cannot be transferred to any other state and it can only be transferred to the same state. Company B, being agitated by the order, being agreed by the order, filed the writ petition before the Gujarat High Court, saying that under Section 18(3) or Rule 41, there is no mandate or there is no provision that says that in case of amalgamation, ITC can be transferred only within the same state. It is simply written under both the section both the sections as well as the rules that ITC can be transferred whether within the same state or the different states. And one more peculiar fact in this case was that the ITC that they were transferring pertained only to central GST. So the ITC of the central GST was also denied to be transferred. The High Court observed the case, listened to both the parties, and particularly relying on one of the judgments of Umicore AutoCAD India Private Limited of the Bombay High Court, wherein the similar facts were there. It was ruled by the Gujarat High Court as well as the Bombay High Court that nowhere under the law it is written that the ITC can be transferred only within the same state. Now, when the respondent, that is a department, said that there is no provision or there is no mechanism on the GST portal by which they can allow or they can, accept the ITC 02 of the taxpayer, so that is why they rejected it. So the High Court again said that this is just an abrupt reasoning, and if there is, the portal cannot govern the law. The law should govern the portal. So what is happening under GST in most of the times that we see is the law is being governed by the portal and not by what is written under the law or the rules. So the High Court specifically said even if there is no provision under the portal to transfer the ITC to different state, the department should take action to transfer that ITC manually, and that ITC should be allowed to company B whether it is registered in the same state or to a different state.
Yes, the department right now, department is focusing more on GST portal rather than the law. And when you consider that portal is okay, portal will be the final. So in some cases, the portal is in the favor of the taxpayer. Like we are filing the GSTR 1, we have filed so many GSTR 1 later, and there were late fee provision for the GST as per GST law. Portal has not collected the same. Now the portal not collected. Now you consider the portal and you don't issue the notice to the taxpayer to pay the late fees. So now when the portal has not taken, you are going for the further notice. If portal is not allowing, then also you have to you always have to take the substance towards the law only. You don't go for the portal. If portal doesn't provide any mechanism for the submission of in the case of the IGST, then you have to take it on hard copy basis, and that has been taken by the court also, that you must accept the submission made in hard copy because it's your weakness, it's your weakness that you are not providing the same.
In the lot of cases also that we have dealt, we have seen the officer, saying very casual in a casual manner and very confidently,
Yes.
since the portal will not allow, so I will not do this or I will not do this. The portal, they do not they do not give any heed to whatever is written in the law.
Yes.
So yes. Another important case law, or that I would like to take up is of Punjab and Haryana High Court in the case of Haryana State Electricity Regulatory Commission versus Union of India and others. Interesting case law in terms of what should be the regulatory functions and what should constitute as business, especially when these public authorities are concerned. This dispute is not new in the GST regime. This is an old regime continuing from the service tax point of view, from the service tax regime, that whatever the functions are being carried out, especially by the local authority or the public authority, whether they should be constituted as the function entrusted to them under Article 243G or Article 243W of the Constitution of India, and therefore they should be seen as the statutory functions or the regulatory functions, and the tax on them should not be levied, or whether simply they are carrying out any business, and they should be treated as a normal taxpayer, and the GST should be levied on them. So again, in a similar kind of judgment, tax was levied on this Haryana Electricity Board on by the department on collecting tariff petition fee and license fee. So what is tariff petition fee and license fee, or the interstate electricity or issuance of interstate transmission of electricity, is that they collect different charges under, like, license fee. If I am giving any license to someone to, you can also redistribute the electricity, or any other kind of license, that is under the mainly under the Electricity Act, because the entire electricity is governed by the Electricity Act 2003. So now regulation of tariff, whether interstate transmission of electricity or issuance of licenses, any kind of amount that is being covered, the department said that they are not per se the part of the regulatory functions, and only the transmission and distribution of electricity is the part of the regulatory functions. Therefore, any collection of the license fees by the department, by the electricity board, or any other kind of fees that is being collected under any other name, alias, it should not be considered as the regulatory function under Article 243G or Article 243W, and hence the tax on the same should be levied. So this is not a new judgment. There were various issues under the old regime also, and one of the judgments that the petition relied upon was the Central Electricity Regulatory Commission versus the Additional Director General DGGI of the Delhi High Court under GST, wherein the similar issue again arose for consideration by the High Court, and in that the High Court clearly held that only the main functions are not covered under the regulatory functions. The ancillary functions which are required to be carried out, which supports the main functions, are also covered under the regulatory functions, and that should also be exempt. So granting of license also supports in the transmission and distribution of electricity. If the license will not be granted, then there will be no further sub-distribution of electricity by the various licensees that are available in the market. Or when they will not collect any interstate electricity charges, then they will not be able to supply those electricity, and all these charges that are being collected by them are whether written under the law, or if these are the public authorities or the local authorities, then these charges are governed by their rules and regulations. Whatever they are collecting is not beyond that. So since these are the ancillary functions which supports the main functions, therefore they should also be considered as the part of the regulatory functions, and tax on them should not be levied. So I think this is not, I must say, one of a kind judgment, but an important judgment for the whosoever deals with the public authorities, whosoever has the clients of local authorities, say ESIC. Because recently I got one judgment of the one notice of the ESIC also. So yes, whosoever has the public authority or local authority as their clients, they can use these type of judgments wherever the department is levying tax, or challenging that whatever the amount they are collecting is not considered as the regulatory function. These are the important judgments for them.
Yes.
Next judgment that I would like to take up is again of the Gujarat High Court in the case of Singhvi Trading LLP versus State of Gujarat. Small judgment, important judgment, again on the violation of the principles of natural justice, that the department, why it is important is that in many of the cases we see that the department rely on the statement of one person and then make the whole case on the basis of that statement only. If I say that person A and me has done the fraud, by colluding, or that person, I know that person A has done this, person A and me are friends, and we have done this together. What the department will do, it will make the whole case on person A on the basis of my statement, and they will not do any independent analysis of the evidences, or they will not try to gather much more evidences which corroborate the statement that is being given by me to substantiate that yes, whatever I have said in my statement is correct. What they will do is that they will eventually rely on my judgment entirely and will make the entire case of that on the basis of my judgment only, on my statement only. So in this case also, a case on Singvi traders, on Singvi trade link, the show cause notice was issued on the basis, only on the basis of the on the statement of certain persons, and also relied upon documents. That is also very important, that the department,
Yes.
whenever they issue show cause notice, they write RUD1, RUD2, RUD3. So these are the relied upon documents. RUD, relied upon documents, on the basis of which department makes its case. It's like similar to annexures that we give under the reply or the appeal, that whatever we are saying, we are also reproducing annexure 1, we are attaching annexure 1, annexure 2. It is similar for department, it is RUDs. So it is important for department, first of all, to give those RUDs because these are the important documents on the basis of which the show cause notice has been framed. The allegations under the show cause notice has been framed. Two things happened here. First of all, department relied on the statement of a single person, and the cross examination, when the assessee asked for the cross examination of the said person, it was not given. Secondly, relied upon documents were not supplied. Again, the case went to appellate authority, rejected. The case went to high court. Similar type of judgment in this case also, that cross examination is very important to decide whether the statement that has been relied upon by the department is correct or not. If I say something negative about Mr. Gaurav, say if I have some feud with Mr. Gaurav and I say to the department that Gaurav has done this and does this and done this, then Gaurav should have the opportunity to cross-examine me and to bring out the truth on the that why I am saying whatever I am saying, what are the evidences that I have. So that is why cross-examination, not only in this under the service tax or the income tax, whenever the department is relying on any of the person's statements, the cross-examination of that person is very important. And it is my humble advice to all my consultant friends here to every time ask for the cross-examination whenever you see any fake invoicing cases, and especially when the show cause notice is issued on the basis of the statement of certain persons, because in most of the cases department will fail to provide you the cross examination of the said person, as they will not be able to produce that person in front of the court. So this is the very important point, or the cross examination is a very important argument that everyone should take, that whatever allegations have been made in the show cause notice, on the basis of the statement of any single person or one or more person, I want to cross examine all those persons. And similarly, the department again, RUTs were not given. So again, it was again a violation of principles of natural justice, and the case was remanded back by the High Court to the original adjudicating authority to supply the RUDs and as well as to allow the cross examination of the persons.
So same thing we have faced recently in the last month. We have received the notice in our taxpayer case, and the case was related to the fake ITC and non-existent taxpayer. They have issued notice to the approx 70 taxpayer, and they have taken a statement of 10 or 15%, and on the basis of that statement, and some party were non-existent, some parties shop or business were not there, they have passed the order against the all the 70%. And what was there, when we have read the order, we have asked notice, we have received the notice first. Initially inspection has happened, after that they have issued the notice. We have made the submission, and we have raised the point regarding the RUD and the cross examination. Practically, the department is also not even going through the reply. They are just rejecting the same. So it is very important for us that we must raise that point in our reply or submission. Once we raise the same, if the department is not replying or department is not taking that point very seriously, so it is in favor of us. We can
Right.
make that, because mostly case the department is not going through the detailed submission. They just say that we have received the notice from our senior officials, we can't do anything. Just they pass a 2 line, 5 line, one pager is order that we are not satisfied with the reply. They are not going to do point wise counter of the submission that we have made. So it is very helpful. It is very important for us to raise that point, because at the notice level, the department will not reply, and for us, it will be very helpful. Either in appeal, or if the appellate authority is not taking the case in our favor, then the next authority, either tribunal or a high court. Yes.
Sure. I think वैसे तो I have one more judgment to discuss, but it is already 12:45, and I think we should give some. I think we should open the session now for some queries, because it is already 12:45. We have only 15 minutes left for the session.
Yes, yes.
So, participants, if anybody has any queries, they can write in the chatbot, or they can raise their hand and they can unmute themselves. Or otherwise, we will start discussing the queries that we have received in Google Form. Yes, Krishanu Upadhyay ji.
Yes, sir. Good afternoon, sir.
Good afternoon.
Sir, we have experienced that when we face the GST audit under CST Act, CST department, they always try to demand the defaulting amount under Section 74, where the fact is not under 74, that should be under 73. In that cases, what we should do?
Shanuji, first of all, whenever any non-payment of tax is detected at the time of audit, there are many judgments under the central excise or the service tax regime. It is a clear-cut case of non-fraud. Even if the department, yes, even if you agree on the demand that whatever the department has raised the point of non-payment of tax is correct, because it has been detected at the time of audit. What is audit is just, a scrutiny of the books of accounts. It is not any search, it is not any seizure, it
Right.
is not
Yeah.
something that department has unearthed that we were hiding. Audit, what they have taken out non-payment of tax is only from the balance sheets or the books of accounts that we have prepared, and that was already filed with the income tax. If you're a company, that was filed with ROC, so that is a public document. Nothing was secreted in it, nothing was hidden in it. And yeah, it
Right.
is your fault that you started the audit beyond the statutory timeline of section 73. Now the section 73, 74 is okay, but that is their fault. So
Right.
there are many jurisprudence I can say under the service tax and central excise that whenever any demand that is being asked by the department at the time of audit is a proper case of non-fraud, and there is no willful intention. That is, I mean, 73 will only be attracted, not section 74.
Right. Then we should file appeal before the
Yes,
appellate tribunal.
yes, obviously, we should file the appeal. We should fight the case to the High Court level. I think the tribunal in this case will only grant you a favor, not it will not will even go to High Court.
Okay, because they always say that no, our higher authority give pressure us to demand under Section
Sir, they
74.
again, the higher authorities' pressure cannot govern the law, sir.
Right.
Yes.
What is written in the law
Right.
should be followed, not the pressure of the higher authority.
Right. But
And
the
that's
state
why
government
Section
always
7, yes, that's why Section 75 also talks about whenever the case has been issued, appellate authority has power to transfer the case from 74 to 73. Under Section 75, it has clearly mentioned the appellate authority find that the case is not falling under 74. They may also move the case to 73. So we
but
must file the case in such a case where the audit or and the audit department are finding any kind of tax no payment, because the mens rea is very important. If mens rea is
right.
not wrong here, not nullified, then 74 will not be applicable, and the reason to believe will have to provide by the department. So why it's 74? It's not on us, it's on department. So
Because
you must,
they try to the Section 74 because the limitation ground. They always try
yeah,
to take the demand under 74 only because the limitation ground.
Yes, that is why they issue notice under section 74, because the audits are generally being started late when that statutory time limit
Yeah.
of 73 is expired. So that is why mostly the notices are under 74 only.
Thank you, sir. Thank you.
Okay. Anybody else would
Sir,
like to ask?
sir, whether 86B will attract section 74 will attract 86B violation, sir. Rule
86,
86, rule 86B.
I got your point, sir. But Rule 86 violations are basically related to, sir, that 1% payment of tax, right?
Yeah, yes.
Right.
Sir, that 1% of payment of tax, how can they attract, and how can we be under section 74, sir? Tell me. Because whether I have made the payment of 1% of tax or not is, where can be verified easily from the returns I have filed.
Yes.
And whether I am falling under the exemptions or not can be, but there are various exemptions to it. of 1%, that can also be verified from my balance sheet or from my income tax returns on whatever even if the
Yes.
refund, if I am claiming refunds
Yes.
as well, then can be verified from the GST portal. So
Yes.
what is that the department has to go one step ahead and find out that I have not made the 1% payment of tax or I have evaded the payment of tax? Nothing. There is
Yes,
no extra
because
effort
what-
put in by the department. Sir,
What they have
listen,
done-
74 can be applied only when you are hiding something and department
Yes.
is putting an extra effort to
Ah.
find out the truth.
Yes, correct. Because one case, we have received the notice under section 74 for 86B violation. We have filed the appeal that we have questioned the validity of a notice.
Correct?
Yeah, correct.
Is it correct, sir?
Correct, sir. 86B cannot attract section 74, sir.
Yeah.
You have
Okay. Thank
already
you.
made the payment of tax. You have not, in 86B case, you have already made the payment of tax through credit
No,
ledger.
no, sir. Whatsoever, sir. This is again the time limitation. 73 time limitation exerts. They should notice
Yeah,
under section 74.
Yes,
but
because
that
of time limitations only, sir. Mainly section 74 notices, that is, I am not seeing from only in the GST regime only, sir. Yes, that I am seeing from the old regime, the central excise or the service tax also, mostly because section 74 or 73 provision to section 73(1) under the Finance Act 1994, mostly they are attracted because the time limit and the normal limitation
Yeah.
of period is expired. So they do
Okay.
not have any other option just to invoke that section 74 or that fraud section and provision to section 73(1).
Okay. Okay. Thank you so much, sir.
Yes. Ajay Jain ji has mentioned one that they also issue notice under section 122. Can they issue notice under this section? Sir, what kind of notice that they have issued under section 122? Is it only a penalty notice or what kind of notice? If you can, just unmute yourself and explain.
हेलो
Hello.
हाँ फेक इनवॉइस वाले केस में जो टाइम लिमिट उनकी 73 74 दोनों की पूरी होगी तब उन्होंने पेनल्टी के लिए 122 में नोटिस दिया
नहीं सर
सेल 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 ऑफ ये केस भी है आउटवर्ड सप्लाई का नॉट इनवर्ड सप्लाई का
सर केवल सेक्शन 75 में या आई थिंक 75(11) है या कोई सेक्शन है जिसमें ये लिखा है कि जहां पे सेल्फ असेस्ड टैक्स पे ना हुआ हो वहां पे डिपार्टमेंट बिना नोटिस के रिकवरी कर सकता है और वहां पे कोई टाइम लिमिट नहीं है सर। वो भी जनरल लिमिटेशन वहां पे भी अप्लाई होगा। वहां पे भी सर्कुलर है कि आप पहली बार में सीधे रिकवरी प्रोसीडिंग्स शुरू नहीं करेंगे। आप पहले टैक्स पेयर से एक नोटिस देके पूछेंगे कि जैसे कि सेल्फ असेस टैक्स क्या होता है सर, मैंने R1 में 10 लाख का टैक्स डिक्लेयर किया और 3B में केवल 2 लाख का टैक्स पे किया, दैट इज ओनली अ सेल्फ असेस टैक्स, नथिंग एल्स। उसमें भी मेरे से गलती हो सकती है R1 भरने में, इसलिए मैंने 3B में कम टैक्स पे कर दिया। इसीलिए उसमें भी एक सर्कुलर है, क्लैरिफिकेशन है डिपार्टमेंट का, गवर्नमेंट का डायरेक्टली डिपार्टमेंट्स को इंटरनल क्लैरिफिकेशन है कि आप डायरेक्टली उसमें भी रिकवरी प्रोसीडिंग्स शुरू नहीं करेंगे। अदरवाइज अगर कोई पेनल्टी नोटिस है सेक्शन 122(2) में, दैट आल्सो शुड अडहेयर टू द टाइमलाइंस गिवन अंडर सेक्शन 74। दे कैन नॉट इशू एनी नोटिस। अगर सेक्शन 74 क्रॉस हो गया तो फिर आपको ना ही पेनल्टी जमा करना है, ना इंटरेस्ट जमा करना है और ना ही टैक्स जमा करना है।
ना तो 73 हुआ ना 74 लगाया, उन्होंने सीधा 122 में नोटिस दिया कि आपने जिसको सप्लाई किया है वो जो बायर है वो फेक है।
सर कुछ समझ आया नहीं।
मतलब अपने तो सप्लाई करी,
ठीक है,
और माल बेचा किसी को,
ठीक है,
और जिसको माल बेचा वो फेक हो गया,
वो गायब हो गया। अच्छा, ठीक है,
और उसमें क्या कहते हैं फेक सप्लाई मान करके,
ठीक है,
और 122 में नोटिस दिया है।
ठीक है।
तो वो
नहीं, यहाँ
122
पे
में
तो केवल
नोटिस
वायलेशन ही 122 का है ना। आपने सप्लाई करा या ना करा हो, बट आपने टैक्स तो पे करा ही है, तो वो आपसे
हाँ,
टैक्स
टैक्स पे
मांग
करा
नहीं
हुआ है,
सकते।
टैक्स नहीं मांग रहे, पेनल्टी मांग रहे हो तो
पेनल्टी मांगेगी 122 में पेनल्टी मांगेगी, बट दैट आल्सो हैज टू बी अंडर द टाइम लिमिट ऑफ सेक्शन 74 सर।
और सर अगर 74 की टाइम लिमिट निकल गई तो नहीं मांग सकते हो।
तो कुछ नहीं हो सकता सर।
74 भी
निकल गई, they
लोगों
cannot
का
recover anything सर।
नहीं, हमारी मिसलीडिंग नहीं है ना इन्फॉर्मेशन, क्योंकि हमने तो इन्फॉर्मेशन सही दी है, सामने वाला फेक हो गया तो उसका क्या करना।
सॉरी,
भाई मेरे पास कोई आदमी माल खरीदने आया,
हाँ, उससे कह दिया
मेरे
कि
से माल, उसने कहा ये मेरा जीएसटी नंबर है, और मैंने उसको माल भेज दिया।
ठीक है सर।
अब वो सामने वाला फेक है ओरिजिनल है, मेरे को क्या मतलब।
हाँ,
तो मैंने उसका जीएसटी नंबर मांगा और जीएसटी नंबर के एड्रेस में माल भेज दिया। उस केस में क्या कहते हैं 74 में लगेगा।
सर
भाई
उसने
मैंने तो
जीएसटी नंबर किसी
जीएसटी
और का दे दिया आपको?
जीएसटी नंबर उसी का दिया, लेकिन वो फेक था,
वो
वो
फेक था।
पार्टी फेक
सर
निकली। हाँ
74 तो डिपार्टमेंट लगाएगा ही, बट आपको प्रूव करना पड़ेगा इस केस में कि 74 क्यों नहीं लगता, कि आपका इसमें कोई कोल्यूजन नहीं था, आपका कोई इसमें आपको पता ही नहीं था, यू वर अनअवेयर ऑफ द ऑल द सर्कमस्टेंसेस व्हाट एवर हैज बीन अनफोल्डेड। तो डिपार्टमेंट की तरफ से तो वो डिपार्टमेंट 74 ही लगाएगा, बट इफ यू कैन प्रूव बियॉन्ड डाउट दैट और मे बी
उन्होंने
रीजनेबल डाउट।
नोटिस में 74 भी मेंशन नहीं करा हुआ, उन्होंने सीधा 122 में नोटिस दिया हुआ है।
वो सीधे 122 में पेनल्टी लगा दिया होगा ना सर उसमें?
हाँ हाँ, नहीं नोटिस ही 122 में दिया है।
हाँ 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 सर, उसको 74 के टाइमलाइन के अगर वो क्रॉस कर गया तो आप मतलब फिर तो आप बेफिक्र रहिए।
ठीक है, थैंक यू।
ठीक है। There is one query on the Google form that I would like to take that up first, then we can discuss more queries. Uh, just a second. Yes, the query was, my dealer has received the notice for late fee and penalty for delayed filing of CMP 08. The officer dropped the late fee and penalty after my dealer replied that the tax has been paid along with interest. Now we have received APL 03 for review the order. The commissioner is saying that penalty is applicable under section 7311 for the tax paid after 30 days. My question was that if one officer dropped the penalty, can again the penalty be initiated by the commissioner? That is, it will not mean change of opinion. Further, we have paid tax along with interest through CMP 08 before issuance of SCN. That is, it was paid while filing CMP 08. Is it legally possible to initiate penalty under section 7311? Okay. So I will just, summarize the query. What the person has asked is, while the CMP 08 is filed in the case of the composition dealer, they somehow filed that return late. But whenever the return was filed, they paid the tax as well as the interest at the time of filing of the return only. Later on, the department came and said that since you have filed the late return, you are liable to pay late fees as well as the penalty for non-payment of tax. As what I believe under section 73, the department may have asked for the 10% payment of 10% of the tax amount as penalty under section 73. Maybe the officer dropped late fees, maybe because it was paid at the time of CMP 08 only. But yes, what the queries mentions the fact that the late fees was dropped by the officer and the penalty was also dropped. But later on, that order went on for the review, and the commissioner decided that the penalty was not that the penalty dropped by the officer was not was not eligible to be dropped, as it was the tax was paid after 30 days or so. There are two questions that the person that the querist has asked in this case is, first of all, that the review of the order, is it the change of the opinion? Second, whether the penalty under section 73 can be levied. Section 73 can be, if the person is in the meeting, whosoever, Krishna. Okay. So, yes. For the first question, that whether there is a change of the opinion or not, that I would like to say, sir, that the commissioner has the power to review all the orders under section 108, I suppose. Yes, 108, they have the power to review the orders passed by the adjudicating authority and file an appeal if they think that the order passed by that adjudicating authority is not correct. So whatever has been done by the commissioner by reviewing the order and by filing the appeal is within the four corners of the law, is as per the law, and this cannot be construed as a change of opinion, first of all, because they have that power in the law. Right. Second question is whether 73 penalty under section 73, that is the commission is saying was dropped incorrectly, there you are on a stronger footing because you have paid the tax as well as the interest. Tax as well as the interest before the issuance of the SCN, and that is the fulfillment of conditions written under section 73(5), I suppose. 73(5), yes. Section 73(5) clearly says that if the tax along with interest is paid, then the show cause, before the show cause notice, then the penalty under section 73 will not be levied. It will not be attracted.
Yes.
So what you should do in this case, you should fight the case. You should not fight the case on the ground that this is a change of opinion or that they do not have the power, because they do have the power. But you should fight the case on the basis that yes, whatever the tax and interest has been paid, therefore the penalty is not invocable, is not payable. Gaurav, if you have anything else on this,
Yes. Since the tax has already been paid, then the penalty will not be applicable in the case of the 73. If the case was opened in 74, then there might be situation different. But in 73 case, the tax has already been paid, then department can't raise the concern regarding the penalty. Yes, they can review the order passed by the lower authority, so they have the power. You can't say that they can't change the opinion. But after the submission, the penalty will not be applicable.
right. I think yes, the queries in this case is also mentioned on circular, that is circular number 76 of 2018. That is yes, that I think as far as I remember, that circular is related to GSTR 3B, but yes, the same principle will apply to CMP 08 as well, because this is also written as in a similar nature to GSTR 3B. So yes, the whatever is written under circular 76 will also apply here also.
Yes.
Okay. I think we can take one or more two queries as well if anybody has any query.
Yeah.
Or if nobody has any query, then Govinda Wadhwani, yes, please. Sir.
Good afternoon, sir.
Good afternoon.
So, my client canceled the registration in 2022. In 2026, client know the notice after the recovery proceeding by the officer. Now, my question is, can I go for appeal on the basis of the communication order now? If I go up in appeal, can I write in the appeal condonation delay or not?
Sir, your registration was cancelled, and then your some assessment order was passed against you.
Yes. In 2023, near about
23, and you could not access your portal at that time, right?
Yes. Or client already change the place of the business also.
Okay, and did you receive that on any email?
No, sir, no.
See, sir, if you can clearly establish that you have or not, that order was not communicated to you, that order was not served to you. Because first of all, what the department has done by, uploading the registration on the cancelled, uploading the order on the cancelled GST registration is wrong. We have one or two few cases of the high courts as well in this case, wherein they have clearly said that if the registration is cancelled and then after that you are uploading some order, that is not an effective communication. You should also email that, or you should also courier that. Now, when you say that they couriered the notice or the order, but that too on the old address and the new address was changed, that is again not your fault, because you cancelled the registration and you were eligible, or you were you could have changed that registration that address clearly. So what you have to prove beyond doubt is that you were not communicated that order, I think, and I think in this case, because your registration was cancelled, you do have a good case to fight. Now, practically, what I will say is that the department at the lower level, that is at this level, in the commissioner's level, will not agree to you.
Yes.
And they will obviously, and also they do not have the power to condone beyond 30 days. Yes, 30 days applies from the date of communication of the order, You have to say establish that this has been communicated now only, but practically they will not agree to it. But you have to have a good chance in High Court to fight this case.
Okay, it can be possible in iterate.
High Court, yes, sir, definitely it is possible.
If first I'll try to appeal in first appellate. He is rejected. Then after I can go in iterate.
Yes, yes, sir.
Yes, yes.
Yes, first of all,
Okay.
you should go to first appellate authority only, because that is, you have the alternate remedy available. Otherwise, the High Court will say, how can you come to us directly, establishing
Yeah.
that the order was not communicated to you? Because if you can convince the first appellate authority that the order was communicated to you late only, then then they have to listen to you as well. Because 90 days starts from the date of communication of the order, when the order was served to you.
Okay, so only one short question. Can I, at the time of file appeal, can I write the condonation delay or not?
Sir, see, you should write the communication date whenever it was communicated to you, and if you're filing the appeal beyond 90 days, then only you should write the condonation. Otherwise you should not ask for condonation of delay, because there is no delay on your part.
Yes, sir.
Yes.
Yes. Okay. Okay. Thank you so much, sir. Thank you.
Okay, I think we can end the session now.
Yes.
Thank you, everyone. Thank you for joining us. Thank you for listening to us. We will meet at the same time next week with some different topics, different case laws. Meanwhile, you can also send your queries to us on a Google form, and which we will definitely take up in the next session. Thank you, everyone.
Thank you.